Welcome to Inside Safety, a podcast series by Herbert Smith Freehills Kramer that explores the latest developments in workplace health and safety law and practice.
Hello and welcome to the second episode of the new Inside Safety podcast from the Herbert Smith Freehills Employment, Industrial Relations and Safety team. My name is Olga Klimczak and I'm one of the partners in the Perth team, and I'm very pleased today to be joining you in Gadigal country here in Sydney with one of my partners from the Sydney office, Nerida. Nerida, welcome and thanks for having me.
Thanks, Olga. It's great to be here.
Well, today we wanted to begin by acknowledging the traditional owners of the lands on which we work. So obviously the Gadigal people of the Aurora Nation and the Whadjuk people of the Noongar Nation from my home state. Now, the risk of silicosis has been around for a very long time. It's fair to say it's a hazard that's well known. And over a decade ago, we saw class actions in the gold mining industry across the globe. So why are we talking about this issue all of a sudden? Why has this become an issue, Nerida?
Yeah, it's interesting. It really is an issue that's re-emerged, I think, into prominence. The reason for that, I think, is a really concerning trend of diagnosis of silicosis and workers dying from the disease, really arising out of the use of engineered stone products, so stonemasons, and really common kitchen products, so bench tops and the like. This has been also emerging, I think, at the same time in other workplaces, in New South Wales in the context of a lot of tunnelling work for our infrastructure projects as well as mining. What that has meant is that over the last few years we've seen a fair shift in focus. This is really front and centre of lawmakers, policymakers, regulators' mind. And that's what I think we'll talk about today. What have been the developments in response to this from the legislature, from the regulators, and from courts, unions and industry, really to bring the focus on protecting workers' health in those industries. So, Olga, I guess let's just start with what's changed in the law. What have we seen?
Yeah, I think there's broadly three key developments that have occurred and one that's coming down the line for our listeners to be aware of. So firstly, obviously we saw the ban on engineered stone from 1 July last year, 2024. And that really was the first in the world in terms of a banning on the use, supply and manufacturing of engineered stone. California did have in 2023 some regulation in relation to dry cutting of those materials, but really Australia has led the charge internationally in this space. Following that regulation in July 2024, in September 2024, we also saw further regulation in relation to the risk of silica more generally. And so we saw stronger regulations in relation to crystalline silica substances. So what that looks like is where there are high-risk workplaces in terms of a risk assessment, PCBUs must then have a silica control plan, and there's detailed regulations around that. And interestingly, while most Australian jurisdictions adopted the model regulations, there are some nuances and differences. So, for example, in my home state, in WA, while the regulations aligned with the model laws, we introduced more rigorous medical requirements, for example, such as mandatory low-dose, high-resolution CT scans, and also we had separate regulations for mine sites because the government had said there were already existing regulations for that. But interestingly, the unions in particular were quite focused on that and have demanded more change to align the mining regulations with the more general regulations. So those were the first two key developments in terms of the legislature. But thirdly, there's also been a lot of regulatory guidance. I mean, across the states, the various, and Safe Work Australia have released a lot of guidance on controls in this space and codes of practice as well. So it's important to be aware of those because obviously, as we know, Nerida, the important thing is that even though these aren't mandatory, they can be used by courts in cases around what does the industry know of these issues and what are reasonably practicable measures. But I think looking to the horizon, there's also this change that's coming down the line in terms of the transition from workplace exposure standards to workplace exposure limits starting from next year. So I think that's an area to be across. But really, it's part of a broader focus on respirable diseases more generally. Certainly in WA, we've seen a big focus on asbestos. There's lots of naturally occurring asbestos across the state, and I think you've got some coal respiratory diseases that are the focus as well, aren't there? But I think given this change in legislative and regulations and also this increased guidance material, I'm sure a lot of our listeners are also wanting to know what are the trends that we're seeing in terms of regulatory activity. So what are you seeing in New South Wales?
Yeah, this has been a really active space. And I think one of the real challenges for regulators is the significant lag often between a worker being exposed to a hazard respirable material like silica, like asbestos, and the lag between disease onset. So for some time, 150 years in this state, there have been workers' compensation, civil personal injury type claims arising from occupational diseases, those diseases which are caused, contributed to by exposure to hazardous substances. But more recently, what we've seen is an effort for regulators really to have work health safety laws operate in this space more effectively. So that trend of there being significant personal injury damages available continues. Last year, we saw an award of common law damages for a case of coal mine dust lung disease in New South Wales, and that was an award of $3.2 million in damages for personal injuries. More and more we have seen regulators seek to really step in and establish breach of work health safety obligations of the primary duty. There hasn't been a lot of activity in the silica space as yet in terms of enforcement outcomes. But I think really when you're looking at regulatory behaviour and regulatory approaches, you would look at the exposure type issues. So there was a decision of Safe Work and Orica which concerned cobalt dust management, and that was actually prosecuted under the Category 1 offence provisions in the Work Health Safety Act. As we know, that is the most serious category of offence under that Act, and resulted in a significant penalty of $1.5 million reduced for an early guilty plea. It was an interesting decision to read as well because the court relied on exposure data that was available at the relevant time when this workers were exposed to the cobalt dust. And the defence argued that really the exposure should be measured by each of those occasions where there wasn't an exposure recorded. And the court said, well, no, that is really denying reality, that there were only exposures on those particular occasions and that there was a lot of red flags available to the company, that it really should have picked up on this foreseeable risk to workers at the time. More recently, there have been a couple of decisions which have been decided in the silica space. So the first one was a decision last year, Court of Criminal Appeal dismissed a charge which had been commenced by Safe Work. Safe Work had commenced proceedings, so under our New South Wales Work Health Safety Act, you have 2 years to bring a charge against a duty holder from the date that the offence becomes known to our regulator. Safe Work commenced proceedings within 2 years from the date that it was notified of the deaths of these workers who had been exposed to silica from stone cutting. And the defendant was able, on appeal, to have those charges against it dismissed on the basis that that charge had been brought out of time. It said, and successfully argued, that Safe Work were on notice of the offence prior to being notified of the death of those workers because Safe Work had actually engaged with that employer in the workplace and issued improvement notices and taken enforcement action, lower level enforcement action at the time of the relevant exposure, and the court said that's correct. Safe Work was on notice of these breaches at the time that it became aware of the exposure rather than at the time that it became aware of the injury to workers. So that is a significant difficulty for regulators in this space. Safe Work took it to seek special leave to appeal to the High Court. It was not successful, and so that precedent stands. We've since then, in the last few months, had a decision which has fallen the other way. Safe Work was able to to successfully prosecute a duty holder in relation to similar circumstances. So it does fall on the facts of the case, but it does present a real difficulty for safe work. So one of the things that safe work, as long as the law stays as it is, and I don't think we'd be surprised if we saw legislative change, but as long as the law is as it stands, safe work will be very, very motivated to take enforcement action and commence prosecutions absent being notified of health monitoring outcomes, really at the time that it becomes aware of exposure. And so what we are seeing is a really, really active regulatory and investigation environment for safe work. There is in our regulator here a silica task force which has been established really to advise the regulator and the government on the best way to use WA test laws to protect workers' health in this space. And I think given the prominence of this issue, you know, we've had in New South Wales, there's been a lot of media coverage on this. There has been a parliamentary inquiry. What we have is a very, very motivated regulator who will continue to have that presence and the inspections and what we have seen for a long time. But I think that there will be some motivation to seek prosecution outcomes as well. So I just wanted to ask you, I guess, your view and your experience in WA, your regulator and how they're responding to some of these concerns.
Yeah, and it's interesting because we've seen a lot of regulatory activity in terms of inspections and some of that lower level enforcement action, but no cases as yet. I think New South Wales is leading the charge there. But I think a lot of regulators around the country will be watching what's happening in New South Wales, and they do often speak to each other. I know with the Respect at Work reforms, for example, WA, because of our parliamentary inquiry, was really at the forefront of a lot of changes there. And the WA regulator openly said they were speaking to the Queensland regulator about that. So I expect that some of the regulators across the country may well be coming to New South Wales and speaking to the regulator about what they're doing, and we'll see knock-on effects to other states. But at this stage, what we're seeing in WA is that lower level enforcement. Interestingly, I went to a conference last year, in February last year, where the regulator had said that the mining industry was doing quite well in terms of controlling the risks. But then later last year, in terms of enforcement activity, we saw publicly reported that the Fortescue's Iron Bridge mine received some regulatory activity because of dust there, and that mine in particular has a higher content of silica. So I think clients can't rest on what they're doing. It needs to be a constant proactive vigilance in this space because this issue can arise at a whole range of points in the processing and extraction processing and exporting of various mining products, but also in a lot of other sectors. So I've been speaking to a lot of clients where they're in sectors that you wouldn't think might have this issue. But for example, they might have some cement in one of their manufacturing processes or even in a warehouse, and someone sweeping that could be exposed to silica dust. So, or other areas where there might be geologists where there's rocks being crushed, not necessarily in mine sites, but in other related areas. So it's interesting. I've been speaking to clients in areas that are not traditionally silica focused, but it reinforces the need that because of the regulator being so active, that all clients and workplaces do need to risk assess and have a look at what they're doing, because it's a broader issue than just those traditional construction, tunnelling, mining. I think it's a lesson that a lot of different workplaces should consider this issue, because WorkSafe in WA has identified 4 priorities, and one of them is respirable diseases. And they've said they've got a dust strategy. They've said they're about to release a checklist for audits to give to industry to be able to help with that, which indicates that they'll probably then be conducting further audits. And interestingly, I think when we talk about what the focus will be, it's important to talk about controls and hierarchy of controls and what people can expect in enforcement activities. Obviously, you've got, elimination, engineering, administrative controls as a last resort. But what we're seeing in terms of the types of things that regulators are looking at, it's, can you eliminate it? what about water suppression? What about ventilation? What about certain types of masks as a last resort? But they are focused on all of these controls in terms of their activity.
Yeah.
So it's an interesting time to be thinking about this issue. But I think one of the perennial issues is also contractor safety management. I mean, a lot of these workplaces where this issue arises, there's a lot of PCBs on site, large construction projects, large mining projects. So I think, that's an issue that a lot of clients are faced with.
Yeah, this certainly has been spoken about a lot. When you're talking about some of those higher order controls and you're talking about, can we reduce dust at the source? Is there ventilation available? Are there other technologies that we can adopt? You're talking about a cost. And so the expectation is, given the significance of this issue for projects, that is a discussion that will be had along the contractual chain. The other issue is there is a lot of data arising out of the way that these exposure type diseases are managed. There is monitoring, personal monitoring, seg monitoring. So there's a lot of data that's coming out of projects. There is health monitoring in many industries and health surveillance. And there are medical pathways for workers in industry to be managed along those pathways. So there is quite a bit of data which everybody in the contractual chain can have oversight of how these risks are being managed. I will also say that there is the issue of having the controls in place and are they being implemented. Some of the controls, in particular, I think the PPE controls, there has been reports of at times casual approach to enforcing those controls. Some of them aren't that pleasant to wear, for example. And so I think that there will be a focus on everybody in the contractual chain having some level of responsibility, monitoring, oversight of this, depending on where you sit in that contractual chain. So I think that issue of contractor oversight is something that will come into play as well.
And on data, the regulator in WA said that they will actually be undertaking some new research in relation to exposure, in terms of long-term exposure in mining and other workplaces. So I think there's more research to come down the line too, which might also assist with controls, but also generates another level of data to talk about. And one of the other interesting trends that I've noticed is that overlap between the IR and safety. And this is an issue that we've talked about I think the Inside IR podcast has a recent episode on this. So an important one to listen to. This is an area also where we've seen, at least in WA, a lot of union sort of Facebook posts on this issue in the mining industry, putting pressure on, particularly because there's a lot of bargaining happening or push for bargaining in the mining sector in WA, which has traditionally not had a lot of bargaining. So we're seeing that overlap between IR and safety in this space too, and I think it's an important issue to be aware of and just monitor.
Yep.
So that was a really great discussion. Do you have any final thoughts in terms of themes or trends before we close off for our listeners?
Yeah, I think I think this will be a space to watch, to see. I think there are going to be further legislative changes, and there certainly will be some watch this space in terms of regulatory responses to make sure that WHS laws are working effectively to protect workers' health in this space. I think there's, commenting on the overlap between IR and safety. Again, there's employment and discrimination issues that arise out of this as well, and privacy issues. Given the high level of health monitoring that workers will have over careers, and they tend to move from projects to mine to jobs, one of the management pathways is focusing on early diagnosis and using the best technology to get early diagnosis. But also where we have workers who have adverse indications at some stage in their career, whether it be occupational or non-occupational as well. I know that's arisen in the coal mining industry. How do you manage workers who, as part of their treatment pathways, are being taken out of, dusty environments? So there is a little employment overlay on all of this as well for workers who are impacted.
And I think the other interesting thing actually is also the environment overlay, because, the workplace health and safety laws apply in terms of the workplaces and the potential impact for the public on the workplace. But the environment laws then kick in where there might be a potential exposure to the public, and particularly if there are dusty environments that then spill over into the community more generally. There's that issue as well of community engagement, of environmental issues. So it's a very complex area when you have these issues being more significant, and how do you control that to limit that that dust. So it's an interesting and complex area, and a challenge for many of our clients, but it is an important one to watch given that increase that we've discussed today in focus, and also because of the increase in penalties that we've seen more recently as well, that trend. So one for safety professionals and boards, I think, to be across. Right. Well, thank you so much, Nerida, for joining me today on this Inside Safety podcast. It's been great to hear your feedback and share your insights. And we look forward to speaking on further Inside Safety podcasts. Thank you so much for joining us.
Thank you.